The Australian government and Australian people are concerned for the welfare of animals in this country. Current law and policy fails to protect the welfare of animals, and these flaws are now being recognised. The very existence of animals in Australia rests upon their status in our legal system. In this presentation, I'm going to discuss the current legal status of animals in Australia, the implications of this, and possible recommendations moving forward. Australian law reflects common themes in ancient Roman law and the continental civil law system. Ancient Roman law created a very black and white distinction of a person and a thing, and the rights associated with these clarifications. A person has rights, and a thing is the object of the rights of a person. Legal things included all beings that lacked free will, including women, children, slaves, and animals. Animals and other things were subject to being owned, bought, sold, and taken as possession. A person could be prosecuted for theft if they took someone else's animal or slave. The modern Australian law states that animals hold the legal status of property. Domestic animals are to belong to someone and exist purely as human property. Wild animals are owned by no one while in their natural state, but can be claimed and owned. Early influential philosophers like John Locke and William Blackstone made biblical references in relation to the status of animals. Locke stated that all earthly creatures belong to all mankind, common given by God, and man has dominion over them, holding them as property. Blackstone stated that in the beginning of the world, we are informed by holy right, the all-bountiful Creator gave to man dominion over all the earth, and over the fish of the sea, and over the fowl of the air, and over every living thing that moveth upon the earth. It is clear that the Bible was quite influential to the way mankind viewed animals, and this was reflected in ancient Roman law and still today. The property status of animals is severely detrimental to the basic rights and interests of animals. This status enables cruelty against animals through loopholes by classifying animals as things. Australian people want to see this idea challenged and changed. To challenge this status would mean that animals should be considered persons and should have similar rights, including protection against torture and confinement. In Australia, the property status of animals has not been challenged in court. Option 1 would be to alter existing laws. Gary Francione, an American legal scholar, argues that we must apply the equal considerations principle as part of our moral theory, that decisions should be made to balance the interests of humans and animals. Mike Radford, a British academic, argues that strengthening and development of existing animal regulations can protect animals from being used as things while still being owned. Option 2 would be to change the status of animal ownership to guardianship. Laws in San Francisco have declared pet owners as guardians, which means they must follow distinct regulations in their treatment of animals. Option 3 would be to create two classifications of property, living and non-living property. Living property could possess rights of its own and would incur a legal obligation or duty of care from the owner to the animal. The fourth and most dramatic option would be to change the legal status of animals to persons. A being with legal person status is the subject of legal rights. In America, this case has been challenged in court. American lawyers fought for legal person status for chimpanzees on the basis that chimps were capable of pleasure and suffering, anticipating the future, remembering the past, making conscious choices about their lives, and have the rights to freedom and protection from confinement. With scientific evidence showing the complexity of intelligence and sentience of chimpanzees, it makes a lot of sense that they should be classified as legal persons. The lawyers did not win this case, based on the idea that chimps could not exercise their rights in court, and that the judge did not want them to be the first to take the leap of faith. Any of these options would be an improvement from the current law and policy structure, strengthening existing animal welfare regulations, enabling animals' living property rights, or classifying owners as guardians would allow for more measurable and enforceable standards. These options would enable humans to keep and enjoy animals with a clear duty of care to abide by. These changes would not abolish the idea that animals are things which humans own, but would develop awareness and enforce protection against cruelty to animals. It is important to consider impacts on society, including cultural, economic, and environmental integrities. I believe that most reasonable and sensible practices could still remain with tighter regulation on animal welfare. The dramatic change to a legal person status would have severe implications on the way many cultures live. It would mean, in essence, that everyone would convert to veganism. Farming could not exist, as we would not have the rights to control the life and death of livestock. Fashion production would no longer continue. We couldn't use wool, leather, or fur. Cosmetic companies would be forced to find other means of testing products, and scientific research would be forced to rethink strategies in developing new drugs. Keeping pets for companionship and leisure would no longer be supported. These changes would interfere with religious traditions and beliefs. I believe animals deserve more rights than they currently have, and many practices like farming and entertainment should be abolished. The development of current regulations, as well as the introduction of animal guardianship, would be a solid step in the right direction and would allow protection for animals.